Now in session.
Thank you, Ms. Kraft, and good afternoon. This is day 2 of the Tennessee Court of Criminal Appeals November docket. We're here in Nashville operating under the Zoom protocols, and we appreciate the clerk's office and the AOC who have helped us operate in this fashion during the pandemic to get these oral arguments heard and the cases disposed of. I've been saying this over and over, but it's just as true now. We are very anxious to get back into the courtroom as soon as possible. But in the meantime, this has worked pretty well to help us move the wheels of justice along as they need to be moved. So I'm the presiding judge for this particular panel. My name's Robert Wiedemeyer. I live in Nashville. I'm on the middle section. Also on the middle section, Judge Robert Holloway from Columbia. And from our western section today, Judge Ross Dyer from Memphis. So that's your panel. We will conduct things as we would in court, an actual courtroom, and there's really no differences. We have read your briefs. We have not been assigned the records yet. But we will be, and we'll review those, of course. Each side gets 20 minutes to argue. Mr. Colston, I understand you'd like to reserve 5 minutes of your 20 minutes for rebuttal. Is that right?
I would, Your Honor, if the court please.
All right, that's fine. And with that, I think we're ready. Ms. Kraft, if you'll call the next case, please.
State of Tennessee versus Ronald David Harris.
Thank you. All right, Mr. Colston, you may proceed when you're ready.
May it please the court, Your Honor. Darwin Colston with Mitchell & Mitchell, Rutherford County, Tennessee, for the appellant, Mr. Harris. I would also like to inform the court that Miss Emily Baker is in the room with me. She's a brand new addition to our firm, having just passed the July bar exam. She won't be participating. She's just observing today.
Well, congratulations. Was it Miss Baker?
Yes, Your Honor.
Yeah. Congratulations. That's outstanding. And I know you feel really good about getting that behind you, and we appreciate that. All right, go right ahead.
Thank you, Your Honor. And first, I'd like to say it's a pleasure to be back in front of the court again. It's been quite some time. I've been in front of you before, Judge Wiedemeyer, but the other two honorable judges, this is my first time arguing in front of them. So thank you. If the court, having read the brief, understands this is an appeal from the denial of a post-conviction relief petition, which hinges on really one simple fact. Was it deficient, or one simple question, I should say, was it deficient performance for the trial attorney not to have filed a motion to suppress given the facts of this case? And of course, under the Strickland standard, did the failure to do that prejudice the appellant in this matter? The facts, which I know the court is familiar with, but I'll just recite a couple important ones for my side of the argument, is that Ms. Harris found a hard drive, a detached or external hard drive, if you will, in a drawer belonging to her husband. When she opened that hard drive, she clicked on one folder and saw a thumbnail picture of her daughter. When she opened that file, she saw images of a sexual nature, according to the testimony of the detective at the PCR hearing. She then made a copy of that entire hard drive and took it to the Laverne Police Department. Now, according to Detective Fracker of the Laverne Police Department, he did not have Ms. Harris open the hard drive for him. He took the hard drive from her and opened it himself, and according to his testimony, which has been acknowledged by the state in their brief, went through 10 to 20 files in that computer before he found an image and had her identify it. So first, let me address the first prong of the Strickland standard, which is the deficient performance. Your Honors, I would submit to the court that trying to suppress the search in this matter was literally the only defense available to Mr. Harris. And so the failure to file that motion to suppress or even challenge it at all was deficient performance. When the court gets the record, you will see that there was a motion filed by trial counsel, excuse me, for a bill of particulars, which was answered by the prosecution. Every single count of the 30 that were leveled against Mr. Harris were as a result of the information found on that hard drive. So that is the only evidence. Now, were there interviews with people, the victim, Ms. Harris, after that was found? Yes, but that would fall under the fruit of the poisonous tree, in my opinion. But when we filed our brief, we cited the Sixth Circuit case of the Lichtenberger case, as I'm sure the court saw in my brief. Now, the state has submitted that that is not mandatory authority for the trial court to follow. And I would agree, it's persuasive authority. The reason we relied on the Lichtenberger case is because the facts were so eerily similar to the facts in the instant case. But every single ruling made in Lichtenberger was based upon United States versus Jacobson, which was a United States Supreme Court case from 1984, which would be mandatory authority. As a matter of fact, the Jacobson court said, and I quote, that where a governmental search follows on the heels of a private one, additional invasions of privacy by the government agent must be tested by the degree to which they exceed the scope of the private search. Here, the private search was one file. The government, without a search warrant, went through, by their own testimony, 10 to 20 files. This Jacobson case created what we know now as the private search doctrine by the United States Supreme Court. The government may not exceed the scope of the private search unless it has the right to make an independent search. Your Honor, we submit that what would have been done was that the detective should have, based on her testimony and what she has seen, only looked at the one file that she looked at, and on that basis stopped and obtained a search warrant. There were no exigent circumstances. This hard drive wasn't going anywhere. They simply engaged in an illegal search. So here it was conceded by the state on page 11 of their brief that Detective Fracker could not testify that he viewed only files that Ms. Harris saw. He had no idea. This is a direct violation of the scope of the private search doctrine found in Jacobson. And when trial counsel was questioned about this at the PCR hearing, he stated, first of all, he was unfamiliar with the Lichtenberger case, and he saw no basis whatsoever from any Fourth Amendment challenge to the digital evidence and the search thereof, and to where he could file a motion. That's page 28 page 63 and 64 of the PCR transcripts. So any basis for the search would have to include a Jacobson challenge or any defense. Now, I would submit that the failure to research and do his homework on the private search doctrine was deficient performance. To adopt the state's position here, Your Honors, we would be saying that trial counsel has no obligation to challenge or research the search issue in a client's case, the Fourth Amendment violation, before telling that client to plead guilty and serve 30 years in prison. Your Honors, this would have been a dispositive motion. Now, so that's how, now for the second prong, we have the prejudice to the appellant. The motion to suppress, had it been successful, would have been dispositive of all charges. Okay? And as demonstrated by this direct violation of Strickland by the Laverne Police Department, there is a reasonable possibility that not only counsel's error prejudiced the defendant, but the result would have been different. Now, since it's dispositive, the state pointed out that the appellant didn't testify, that he would have definitely gone to trial had the motion to suppress been granted. But I would submit that he doesn't have to testify to that because there would have been no trial. That would have ended this case. All right. So in conclusion, for my first set of arguments.
Let me ask, before you go, how would it have
Yes,
ended the statutory rape case?
I'm sorry, Your Honor.
How would it have ended the statutory rape charges?
Oh, thank you, Your Honor. Well, the statutory rape, like I said in the bill of particulars, Mr. Harris videoed all these encounters, and all of these videos were on that hard drive. So they would have been suppressed also, Your Honor.
But did the victim testify at trial?
The victim, well, there was no trial. This was a guilty plea, Your Honor,
Okay.
based
The
upon
victim
pressure.
could have testified at trial.
Could have, but Your Honor, I would
Good.
still submit that would have been fruit of the poisonous tree because she would have never been interviewed had this illegal search not taken place. So there would have been no subsequent evidence that the state would have. And so now the trial
You're
court.
saying, wait.
Yes.
I want to follow up on what Judge Holloway is asking. You're saying that the police couldn't have gone back and interviewed the child simply because the scope of the initial review of the computer, they went too far? They couldn't have,
Yes.
they couldn't have interviewed her later about the incident and proceeded on the statutory rape charge?
Well, with the statutory rape charge, maybe, possibly, Your Honor, but that is a lot less serious of a charge as to what the other counts were, which was sexual exploitation of a minor. We're talking about the difference between a Class E felony and the Class B felonies that landed the appellant in prison for 30 years.
Okay.
And so that search should have been challenged. If there are any other questions, unless there are any other questions, I'd like to address the trial court's role in this very briefly.
Let me ask one more question. I don't know exactly. Sometimes when I have these digital type cases, on computers and things, I try to put them in a more old fashioned thing like regular photographs in an album or
Yes.
slides in a box. So if the petitioner had left these slides, say, in a box on the dresser in his bedroom that he shares with his wife, does that change the private nature of the slides and his right to privacy?
I'm sorry, Judge, I didn't mean to interrupt. I thought you were.
I'm sorry, his expectation and his right to privacy.
I think there is a difference because, as the court said, even though persuasive authority, the court said in Lichtenberger that people's entire lives are on their computers now. Their entire lives are not in a box of old photos. And so that computer deserves more protections from unwarranted searches than a box of old photos. I'm paraphrasing, of course, but using Your Honor's example there. I was just going to go on to say that the trial court also, how they erred in not granting that in their order denying post-conviction, the trial court found that there was no evidence the subsequent viewing of the device exceeded the scope of the private search. That's simply not true. That was exactly Detective Fracker's testimony that he searched 10, not folders, or 10 to 20 files, and that the Ms. Harris only opened one file. That's blatantly beyond the scope of the private search. And so the trial court erred in that respect.
I'm a little confused after reading the briefs and hearing your argument. I'm not saying it's your fault. I'm just a little confused as to exactly what took place. So as I read the briefs, the mother gets on the computer and she sees something, if I'm not mistaken, labeled San Diego Chargers.
Correct, Your Honor.
File. It's a file, folder, whatever you want to call it, labeled San Diego Chargers. And she clicks on that. And when she does, I guess what I'm hearing you say is there are numerous folders within that folder.
There are numerous files within the folder, Your Honor. Yes.
Okay. So there are numerous images within that folder.
Correct.
Okay. and she recognizes her daughter from one picture on one image, and she clicks on that and it is her daughter.
Which is a file. Yes, Your Honor.
Okay. Well, I guess that's where I'm getting. I understand, to kind of go back to Judge Holloway's point of let's go old school with this a little bit. I mean, yes, a picture saved on my computer is considered a quote file,
Yes.
but here is how I'm picturing what took place, and you tell me if I'm wrong. And I'm going to use Judge Holloway's example. There's a box on the desk marked San Diego Chargers. I open that box, and in that box are there numerous pictures, or in that box are there numerous files in which if I pull out one of the manila envelopes, there's a picture inside that envelope. Does that make sense what I'm saying?
Yeah, I think I know what you're saying, Judge Dyer. What my understanding is that when she opened the folder, yes, you're correct. There are numerous files, and those files can have an icon attached to them. And in this case, my understanding is the icon was a picture of her daughter on that file folder that file within the folder. She then clicked upon that one file and saw sexual images of her daughter. That's when she stopped and made the copy. But the detective looked through 10 of those.
Okay. So using my analogy, what you're saying happened is we open the banker's box, marked San Diego Chargers. In there's tons of manila files, one with a label on it that says daughter. She pulled that open, and inside that, there's several images. What the detective did was he opened the exact same box and pulled out 10 files and looked through 10 of those.
Exactly, Your Honor.
Okay.
So his search exceeded hers vastly.
Okay.
And I believe my time's up on my portion. I've got 5 minutes saved for rebuttal, I believe.
That's exactly right. Thank you.
Thank you, Your Honor.
Certainly. General Smith, good afternoon. You ready?
I am. Good afternoon, Your Honor. May it please the court. Brandon Smith for the state of Tennessee.
Mr. Smith, I'm going to go ahead and interrupt you. Just explain, using the analogy that Judge Holloway and I've kind of put together here, the old school analogy. What's the correct way of looking at how this officer looked onto this hard drive?
Sure. Well, Your Honor, I would actually compare this not to a banker's box, but how the court in the Sixth Circuit in the Bowers case compared something like this to, which is a photo album.
Okay.
On the front of the San Diego Chargers folder within the hard drive, Mrs. Harris recognized an icon. These folders frequently have these icons, as Mr. Colston explained earlier. When recognizing what she thought to be her daughter, she clicked on the San Diego Chargers file folder, opening it. Within there were multiple files, images and video files, many of which had thumbnail images or icons on them as well. Now, she clicked on one. She may have clicked on more. It's unclear from the record. But what we do know is that Detective Fracker, in his follow-up search, after this folder was copied onto a third device and brought to law enforcement, Detective Fracker opened the first 10 to 20, as he testified, looking for a photo that had a clear and what he would describe as an appropriate picture to use to identify the victim. So much like in the Bowers case, in a photo album, it's not unlawful for law enforcement's follow-up of a private search under the private search doctrine when the officer knows and has reasonable certainty what he's going to find in this file folder.
Okay. Thank you.
Sure. Well, I'm going to start out with what I planned and just make a couple of points here, Your Honor. First, this is a case about ineffective assistance of counsel, and that does turn on the Strickland analysis. And on the first prong, it is simply not deficient for a defense counsel or trial counsel to not utilize or rely on non-binding, merely persuasive authority that's also contested in other federal courts. I think there's a couple of important points to know about the Lichtenberger decision. First, prior to Lichtenberger by 2 years, this court itself had ruled that it's not unlawful for law enforcement to continue to look through files within the same folder after a private searcher had discovered something illegal in those files. In the Dale case, it was a computer repairman who found a file folder that had illegal content in it, much like this case, and saw multiple thumbnails. Moreover, this case is not binding or was not binding on Mr. Nixon, the trial counsel, and it's simply not required that counsel file meritless motions or motions that he feels do not have a likelihood of success. It is appropriate when the defense counsel makes a strategic decision to focus not on a particular motion, but on achieving a plea agreement that seeks the best interest of his client. To prove deficiency, the counsel's acts or omissions must be so serious as to fall below an objective standard. Here, they simply do not do so.
General Smith, let me ask you a quick question.
Sure.
At the post-conviction hearing, did trial counsel testify that he carefully considered the possibility of filing a motion to suppress this evidence because those things that were found by the police officer exceeded the private search, and he looked into the law and decided as a matter of strategy that or just as a matter of the law, that he would not be successful on such a motion, or for some reason didn't pursue it, that was a strategy decision? Because the impression I got from Mr. Colson's argument was that basically, not to be disrespectful, but it sounds like the trial counsel was just ignorant of, just didn't get it and didn't see that that was even an issue. To me, there's a huge difference there in trying to assess whether trial counsel was deficient or not.
Yes, Your Honor. And actually, the trial counsel at the post-conviction hearing testified that as a normal course of his preparation for cases, that one of the first things he looks for is for possible grounds for motions to suppress the evidence. He testified that specifically in this case, he conducted that research knowing that the digital evidence was such a big part of the state's case against him. However, he'd also testified that he found no grounds for a legitimate motion to suppress at that time, but he was, during the testimony, which was a couple of years after the plea agreement and his initial research, that he could not recall precisely what he researched or what issues or cases that he read during that time. Instead, he looked at not just the digital evidence, but the confessions that the defendant offered, both in writing and during an interview, as well as the eyewitness testimony, the forensics interview conducted with the victim in this case, as well as interviews with the mother. Now, looking at this evidence, defense counsel described it as a mountain of evidence and did say that his strategy switched from trying to fight and focus on a fight over a motion that he didn't see grounds for, to trying to achieve a beneficial plea agreement for his client at this point. This was the tactic that he chose, or that he testified that he chose at this moment during the trial or during the pre-trial phase. Now, the second part of Strickland, just to move quickly to there, requires that the counsel that the appellant prove some sort of prejudice against him. Now, in his arguments, the appellant argues that there would be no trial. There would be no trial at all if this was the case. But this isn't how the Strickland analysis works. In order to, in the context of a plea agreement, and especially in the context of a Fourth Amendment motion to suppress, the appellant has to argue that it has to show with evidence that he would likely be meritorious on his Fourth Amendment claim. And here, that's not just the case. The Lichtenberger decision is more complicated than I think what's been described so far for a number of reasons. Besides for not being well established, Lichtenberger itself acknowledges that a government search subsequent to a private search is lawful when the detectives view something like photos that have already been exposed to a private searcher. Now, when making this statement in the Lichtenberger case, they're specifically citing to a Ninth Circuit case, Tosti, where, again, we have a computer repairman who searched multiple files within the same series of folders and the search was upheld when the police subsequently searched those same folders, regardless of whether or not anyone could be for sure that the same images were opened and looked at in what was then described as a slideshow view. Now, beyond this, the two situations we see here are incredibly different. In this case, for example, we have both in Lichtenberger and in this case, we have both defendant and the private searcher sharing a home. In Lichtenberger, the private searcher hacked into the computer of the defendant in that case. Here, Mrs. Harris did not hack into the computer, but just opened it up or opened up the external hard drive device on her computer. And Lichtenberger, the private searcher, searched multiple random files that were anonymously labeled using a numeric code, making what the court then described as a likelihood that legal information could easily be found in those same file folders and files. In Mr. Harris's case, only one file folder was opened and searched, the San Diego Chargers folder. In the Lichtenberger case, files and folders were anonymously labeled. Here, they were not. Law enforcement in the Lichtenberger case testified that they searched multiple files and folders. Here, Detective Fracker testified that he only opened the first few files, 10 to 20 files within the same folder that had already been opened by Mrs. Harris. And finally, in the Lichtenberger case, law enforcement officers specifically testified that he had asked the private searcher who he was conducting the search through to click and open other files that they had not previously accessed before talking with law enforcement. That did not happen here. Detective Fracker merely opened the same file folder again that Ms. Harris had already searched. In summary, it's the plain testimony of the appellant or of the detectives here reveals vast factual differences between these two situations. And so there's no evidence or even argument, I think, that the case would be completely decided by such a motion. Now, I think there's two other points about the prejudice prong of Strickland that I think are worth raising. First, as in the brief state, the appellant did not testify that he would have gone to trial if the suppression of the digital evidence had been granted. In fact, his motivation at the time was to continue to go to trial regardless of whether or not the evidence was there or whether the digital evidence was there or not. Here, the appellant not only testified that he would have declined a negotiated plea offer if the motion was suppressed or filed, or the motion to suppress was filed or granted, but he testified to multiple reasons why he pled guilty unrelated to the existence of the digital evidence at issue in this case. In his own words, at the plea hearing and at the post-conviction hearing, the defendant's decision to plea was not based on the amount of evidence against them, but based on a desire to protect his stepdaughter at the time from a public ordeal that he would drag her through. And again, to try and raise other issues at trial that he felt were relevant at the time. Now, he did testify that he felt he had no choice, but that lack of choice does not stem from the digital evidence any more so than it stems from his own prior confession and the testimony of both his wife and his victim, his stepdaughter, in this case. Finally, when analyzing the prejudice prong, Strickland also requires us to look at whether or not the appellant can show he would have reasonably gone to trial, given the overwhelming evidence of his guilt. So assume for a moment that the motion to suppress was granted, and that the appellant did assert that he would have pled guilty, or he would not have pled guilty, but for this mistake, this alleged mistake of his trial counsel. It's just simply not logical to assume that the appellant would have gone to trial given the weight of the remaining evidence against them. As previously stated, the appellant must show a reasonable probability that but for counsel's errors, he would have pled guilty and insisted on going to trial. So the Primo case, of course. This test is objective, not subjective. And in fact, in a high stakes case for a defendant facing a long sentence, that alone may justify a plea agreement. Here, there were over 30 charges in 2 different counties facing the defendant. Trial counsel was able to negotiate a global plea agreement that resolved all of these cases or all of these charges at once. The defendant who accepts a plea bargain on counsel's advice does not necessarily suffer prejudice when the counsel fails to seek a suppression of evidence, even if it would be a reversible error. Even if so, it would be a reversible error for the court to admit that evidence. And the bare recitation that the defendant would have proceeded to trial was not sufficient to show prejudice either. Here, a rejection of the plea would simply have been illogical, given the scope of the evidence against him at this point. And with that, I think I would just refer back once again to the first prong, or the what I said at the beginning, rather, of my argument, which is simply that under Strickland, they have to be a showing of both deficiency, which we cannot show here, given the research and the testimony of trial counsel at the post-conviction hearing, and we have to show, and the appellant has to show prejudice, which is not shown here, given that he cannot show that his Fourth Amendment claim would have been meritorious, nor that he would have gone to trial but for this alleged mistake. If either of these prongs is not met by the appellant, then this court does not have to address the other prong and can dismiss the case. This is why the state, I'm happy to entertain other questions. I have a few minutes left, but otherwise we rest on our brief and encourage this court to affirm the post-conviction hearing.
General Smith, did the trial court make a credibility determination concerning, or the post-conviction court concerning trial counsel's testimony that he did do the research and he didn't find anything?
The trial court, or the post-conviction court, did refer to that information in its ruling. It did not, I think, expressly describe it as a credibility ruling, but in its rationale stated that it believed the trial counsel's testimony, that he did conduct this research, even though he couldn't then recall it at the time. I don't think he describes it as a credibility determination on the record, but in my opinion, it seems to be what it was.
But if he made it, I guess, if he made it a factual statement, a finding of fact that trial counsel did do this, that, I mean, in essence, that is a credibility determination, is it not?
It is, yes.
All right, thank you, General Smith. Mr. Colston, you've got your 5 minutes for rebuttal.
You're muted, Mr. Colston.
Sorry about that, Your Honor. I got kicked off during Mr. Smith's presentation, and I had to join back in on the meeting. So,
He
thank
conceded the case. Did you not hear that?
you. That's great. We can all go home.
Objection, Your Honor.
Just real quick, I'll thank General Smith for being so good to work with in this case. I always appreciate working with the AG's office on these. They're always great. But on rebuttal, I'd like to say that, when this issue was raised of this going beyond the scope of the private search, the burden shifts to the state to show that the search didn't exceed the scope. And what we have here is direct testimony by Detective Pracker that they could not establish that. Here is from his own testimony, paraphrased in the state's brief on page 11. It says, however, Detective Pracker did not recall whether other files were accessible on the copied hard drive provided by Mrs. Harris, nor if he viewed the exact files Ms. Harris viewed within the San Diego Chargers file folder on the external hard drive found in petitioner's dresser drawer. That simply is exceeding the scope of Strickland. There's no doubt. I'm sorry, not of Strickland, but of Jacobson. All right. And by the way, I wanted to point out the fact the general in his recitation of the facts in Lichtenberg kind of made it sound like that was some just random hacker that hacked into Lichtenberg's computer. It was actually his girlfriend. So it was somebody that lived in the same household as him. And then one other thing, I'm sorry.
I wanted to ask you about that case.
Yes, sir.
Lichtenberg, was that a jury trial or conviction?
Oh, Your Honor, I actually don't.
Right?
I gave the text of that case with my brief, but
Okay.
offhand, I actually can't remember right now.
Right. Well, what I'm getting to now, maybe it was different at the time of this offense, but statutory rape by an authority figure is now a Class B felony.
I think it was different at that time, Your Honor.
It may have been. I haven't had a chance. I just looked at it now. It's Class B. It was amended, I can't tell how, in 2016.
Yeah.
But my point, what bothers me about this case is that this is a guilty plea.
Yes, sir.
Maybe it could have been ineffective assistance of counsel for advising the defendant to plead guilty. But how can there be ineffective assistance of counsel concerning the filing of a motion to suppress when the evidence was never introduced We don't know what evidence the state would have introduced at trial, whether the state would have gone forward with these these pictures that they found or not. And
Your
it just
Honor,
seems to be a gap between ineffective assistance of counsel filing a motion to suppress, and then you have a guilty plea where there's no trial.
Oh, yes, sir, Judge Holloway, I can address that. The appellant testified that he repeatedly asked his counsel to file a motion to suppress this electronic data, and that the basically the response of counsel, according to the appellant at the hearing, was, you need to just swallow this pill. And trial counsel did testify that his strategy changed, and he didn't pursue that, which was way he was instructed by his client, because of the volume of evidence. He changed his strategy from a zealous defense to negotiating a plea agreement. I would submit to the court that the volume of the evidence is irrelevant. What's relevant is there a legitimate challenge to this search under Fourth Amendment grounds, or is there not? And he simply didn't look after that. And I would also submit that if he didn't find any grounds, and that's what he testified to, I didn't find any grounds to suppress, well, he simply didn't look that well. That's where the ineffective assistance comes in. The appellant said he felt threatened because the trial counsel threatened to withdraw from his case if he didn't accept the guilty plea. He felt he had no choice at that point. That's all in the record. Secondly, when the court gets to see the entire record, the bill of particulars, you'll see that every one of these charges, like I mentioned again, as it states in the bill of particulars, it states exactly what on these hard drive formed the basis for each one of the charges that he was charged with,
Including the statutory rapes and
Yes,
the exploitation.
Yes, sir.
Mr. Coles, I just want to ask you a procedural question that came into my mind while you were talking at the beginning of your rebuttal here. And that is, it's clear, the law is very clear that since we're on post-conviction, you have the burden of proving you would have been successful on the suppression motion, correct?
Yes, sir, I agree.
Okay. Well, one of the things you said was, at the beginning of your rebuttal was, well, once we showed this, the burden flips to the state to prove
Yes, sir.
to the contrary. And I don't disagree with you that that's the standard if we were in a regular situation, pre-trial, this, that, and the other. But why all of a sudden does the burden shift to the state when the burden to prove the post-conviction is on you? Does that make sense what I'm asking you?
I think so, Your Honor.
I've never really thought about it till you said it just now. That's why I'm asking the question.
Okay. Obviously, I meant the burden of proof on the motion that it did not exceed the scope. Well, because of the fact in the PCR hearing, the appellant's counsel knew none of this. I mean, he admitted that he didn't find anything that would have helped him on a search. So going back to what Judge Wiedemeyer said, I don't know if it was ignorance or if he just didn't look, but the fact is these cases were easily found on a search that didn't, quite frankly, take 5 minutes.
Yeah, and I understand. I guess the way you made it sound was that the state somehow during the PCR hearing has some sort of burden, and the law is very clear the state has no burden.
Oh, no, I didn't mean to imply that. I meant the state would have the burden on the motion to suppress.
Right.
To show,
yeah. And so that's the procedural kind of question is, if it's all the petitioner's burden at the PCR hearing, including the burden to prove he would have been successful on a motion to suppress, how do we ever really get to that answer? I'm not talking about your case. I'm just talking in general. Like I said, this just kind of popped in my head. How do we ever really get to that answer if the state's not required to prove it or show anything? How can the state prove it was a legitimate search while you're trying to prove it wasn't, when the state doesn't have to prove anything?
Well, as showing that the motion, if filed, would have been unsuccessful, I think they do have to show that the search was in the scope of Jacobson.
Okay.
And that's all I have, unless there are other questions.
All right, seeing none, I thank both attorneys for their excellent briefs and arguments today. And this concludes this case. Ms. Kraft, if you will please adjourn court.
This honorable court of Tennessee stands adjourned.
Thank you.
Thank you.